Afternoon, everyone, and welcome to the District of Columbia Court of Appeals. We're not used to seeing so many people interested in our afternoon arguments, but we have one case on our special sitting this afternoon, and it is number 24 CV 922, District of Columbia Retirement Board versus Office of Employee Appeals.
Your Honor. May it please the Court, William Coglanese for the District of Columbia Retirement Board. If I can, I'd like to reserve 5 minutes for rebuttal.
Sure.
Both this Court's appellate jurisdiction and the merits of this appeal are resolved by a simple syllogism. Ms. Sampson was the General Counsel of the District of Columbia Retirement Board, an independent agency. That means that under the DC Code, she was a member of the Senior Executive Attorney Service, an at-will employee, and not the Career Service. The Office of Employee Appeals therefore had no authority or jurisdiction over her challenge to her termination. That syllogism leads to two conclusions here. First, it means that the Superior Court's decision remanding to the Office of Employee Appeals for fact-finding was a clear error of law, because clear statutory definitions applied to the unambiguous, undisputed fact of Ms. Sampson's position leave no room for a remand. Second, because
the trial judge quote the definitional section of the code, the provision 1608.51 sub 3 defining senior executives attorneys.
You're asking, did the judge quote that
Is that
provision?
in the court's order?
I believe
Was the court aware of that definition?
Yes, we argued this to the Superior Court, and the court was aware and recognized that this could be dispositive of the question of whether OEA had jurisdiction, but remanded for fact-finding into this question. That was a clear error of law because the DC Code leaves no room for any facts. It unequivocally provides that Ms. Sampson's position as a general counsel of an independent agency made her a senior executive attorney service member. And so I'll start by walking through that statutory framework, which informs the clear error of law.
Well, before you get back into it, can we step back a second? This is in an interlocutory posture, so you've been using the phrase clear error of law rather than just error of law, I assume, to reflect that aspect of the case. And I wasn't entirely sure from your brief exactly what you think, how you think that requirement operates. At times it seemed that you were suggesting that as long as it was clear that the trial court's ruling rested on a legal conclusion, and that legal conclusion was wrong, it would be a clear error of law. But I took your reply brief more consonant with what you're saying now to be, for us to intervene at this juncture, we need to be persuaded that there is an error of law, and that error is clear. Is that a correct understanding of your position?
Yes, I think that's right, Your Honor. We are arguing that the question here is one of law, and the error in resolving that question is clear. And I think you can find guidance on this from the decision that this court cited when it introduced the clear error of law exception in Warner v. DC. The court there cited to a decision of the Pennsylvania Commonwealth Court, which was Bethlehem Mines Corporation. And there, the court exercised jurisdiction over an order remanding to an agency for fact-finding on the basis of this clear error of law exception. And in particular, it said it was, quote, manifestly clear that the lower agency from which this decision had been appealed had applied the wrong legal standard. So you had an obvious error, manifestly clear, and it was on a question of law. And that's what we have here as well.
If we were trying to clarify the word clear by using some other term that might or might not shed light on what degree of clarity is required, you used the word obvious just now. Is that a satisfactory synonym from your perspective, or do you think if we're looking for synonyms or clarifying terms, we should be picking something different?
I think obvious works. That's also, I believe, the term used by Ms. Sampson in her brief. I think readily apparent would also suffice. Because when you look at this case and the statutes that we've put forth, they make readily apparent that Ms. Sampson's position was a part of the Senior Executive Attorney Service without any determination needing to be made by DCRB, without any facts that bear on that. So to walk through that statutory framework, the relevant provisions are spread across 4 statutes, but their meaning is plain. So just to lay them out. First, DCRB is an independent agency. That's DC Code 1-711A, the DCRB's charter statute. Second, any attorney who is a general counsel employed by an independent agency is a member of the Senior Executive Attorney Service. That's 1-608.513C. Third, The senior executive attorney service is part of the legal service, which is expressly accepted from the career service. That's 1-608.53A and 1-608.01A. Finally, senior executive attorney service members employed by independent agencies are at-will employees and shall serve at the pleasure of the agency head. That's 1-608.53B and F. The application of those provisions
Can I ask you, I followed you through all of that. Your opponents raise as one of their responses a different set of provisions in 1711, 1711K. So if you want to, their view is that may be true ordinarily, but they have special authorities, and under those special authorities, they had the ability to create a different structure. So what's your response to that?
I believe Judge McLeese. They are citing 711 G2A and K. Those provisions actually just reinforce what I said. So to start with G2A, that provision gives DCRB the authority to appoint employees, and it says that those employees, quote, shall be subject to Chapter 6 of Title I. Chapter 6 contains the provisions that I walked through that make the general counsel of an independent agency a member of the senior executive attorney service. So that's just reinforcing what we've said. Subsection K does not change any of that. It addresses DCRB's authority to, quote, establish classification and compensation policy for its staff. My friend's argument is that that reference to classification policy means the authority to decide which service an employee belongs to, and apparently to put an employee in a service other than what some other provision of the DC Code says that they belong to. But that's not what classification is. Classification is within a service. It's the grades and steps within a service that an employee would belong to. And we can see that because subsection K cross-references subchapter 11 of chapter 6, and that is the subchapter on classification and compensation. And in particular, the first statute in that subchapter, 1-611.01, talks about classification by classes and grades. That's a quote, by classes and grades within services. It's not talking about deciding which service an employee belongs to in the first place. If their argument were right, then 711K if they were correct that gives DCRB authority to put an employee in some service other than what they belong to, you'd need a way to reconcile that with what the DC Code otherwise says. But subsection K doesn't purport to be overriding anything in that manner. And my friend does not have any way to reconcile their reading with the statutes that I've laid out. So the upshot is that the statutory scheme yields one answer. This position is part of the senior executive attorney service, an at-will position. That means that Ms. Sampson, in that role, was not within OEA's jurisdiction as an at-will employee. And that in turn means that there was no jurisdiction over her case in the first place. There's no basis for fact-finding, and the only path left is to vacate the OEA's decision. On that point
It
about...
seems to have taken everyone quite a bit of time to figure this out. I mean, this argument was not made in front of the OEA.
That's right, Your Honor. I think both DCRB and Ms. Sampson, who was DCRB's chief legal officer, operated under a shared misunderstanding of the service to which she belonged. That doesn't change the fact that the parties cannot, by agreement or otherwise, override what the DC Code says. They cannot make Ms. Sampson a member of a service other than to which the DC Code says she belongs. They cannot confer upon OEA authority that it does not have. And I would direct the court to its decision in Chase v. Public Defender Service. We cite this at page 17 of our reply brief. It's 956 A. 2nd 67. I think it involves a pretty similar set of circumstances where the PDS terminated an employee, initially told them they could appeal to OEA. They did so, and then PDS said, actually, we're not subject to the OEA's authority. The employee then argued that they could not reverse course in that manner, and this court wasn't having it. This court looked at the statutes, agreed that there was no authority over PDS in the OEA, and then said, quote, there can be no estoppel. Parties cannot waive subject matter jurisdiction by their conduct or confer it by consent, and the absence of such jurisdiction can be raised at any time. I think that's the situation that we're in here. It would have been better for everybody if they were not operating under this shared misunderstanding, but once we've identified it, the answer is to put an end to the proceedings rather than to perpetuate the problem.
Ask you, I don't know if this point has been made, but I'm just curious if you have any familiarity with it. The posture that we're in is similar to the PDS case you're citing, but different from a lot of the cases where we talk about subject matter jurisdiction and its lack of forfeitability or waivability, which are all internal to the judicial system, is a little bit different in that whether or not OEA lacked jurisdiction, if that's not raised in front of them, and then there's someone who's in front of us trying to have us exercise our jurisdiction to determine something that OEA did, that's not a question directly about our jurisdiction. And so there is a line of authority that in some settings suggests that lack of agency jurisdiction is forfeitable if you don't raise it in front of the agency, subject to some exceptions. Are you familiar with that line of authority, or is that not a line you're familiar with?
I am, but I think that it's answered in this case by a different decision. I would direct this court to its decision in 2020 in American Federation of Government Employees National Office versus the DC Public Employee Relations Board, because there the court was addressing agency authority. And I should give you the citation. This is 237 A3rd 81. And the court specifically addressed this question of an agency's authority, and it acknowledged that it may not be jurisdiction, it may be better termed authority. But just to provide the context there, a union member filed a claim against their local bargaining agent and the national affiliate of that union with PERB. The national union then moved to dismiss, but they did so belatedly, and PERB said, sorry, too late. Your argument that you're not subject to our jurisdiction, we're not going to hear it because you defaulted. This court looked at the relevant laws again and said, no, the union is not subject to PERB's authority, and that argument cannot be waived through default or any other means. And I'll quote from the court's decision. The court said, because an administrative agency is a creature of statute and may not act in excess of its statutory authority, the PERB's broad claim of authority through the use of a default rule applicable to those appropriately before the agency is ultra vires and a nullity. And elsewhere, the court said, an administrative body cannot act effectually where it lacks jurisdiction, and when it does so, its orders are void. So, Your Honor, I think that answers the question, that we are still talking about OEA's statutory authority. It has no authority over at-will employees like members of the Senior Executive Attorney Service. And the parties cannot, through judicial estoppel or any other form of estoppel, create an authority that it does not have.
That situation is slightly different from ours as well, in that it was raised at least belatedly in front of the agency. There definitely is a line of authority that stands for what you're saying. There are a series of cases, going back, I think, to a DC Circuit case called Yardmaster, that seemed to take a different view and seemed to articulate a view that ordinarily you can default a claim that the agency lacked jurisdiction subject to an exception if the agency entirely lacked authority to act, and that the scope of that exception, of course, you'd have to sort out. But are you familiar with the Yardmaster case or cases applying it?
I can't say that I am, Your Honor.
I understand that it's not a point that's been raised. I was just curious if you're aware of that line of authority.
I appreciate it. And the only other point that I would make was that below, this is a JA 50, the Sampson agreed that this issue could be raised at any time. So here, we had no challenge to that. If there are no other questions, I'll reserve the rest of my time.
Thank you.
Good afternoon, Your Honors. Donna Rucker on behalf of the intervener and appellee, Ms. Sampson. Ms. Sampson believes that the lower court in this particular matter had the discretion to remand the question of whether or not subject matter jurisdiction exists. And when doing so, it did so showing that it was within its right, and therefore the argument becomes one, if you're trying to move as the appellant is here, you have to show that this was a final decision that is appealable, which we know it is not. And if not, then you have to basically show that there would be other bases. And we assert for four basic reasons. We contend that the appellee's arguments must fail here today, and specifically starting with the fact that the Superior Court committed what would be deemed clear error in ordering this remand. It fails to establish specifically what is meant as legal error. You have to be clear on that. And there isn't anything that has been offered before this court that establishes that this was actually clear error. Second,
What about, I'm sorry to interrupt.
certainly.
What about the fact that DC Code 1608.51 sub 3 defines senior executive attorney service position to mean an attorney who is a general counsel employed by an independent agency. And I take it that you acknowledge that your client was a general counsel and that the DC Retirement Board is an independent agency, so that would seem to put her in a senior executive attorney service position per statute.
And so, Your Honors, we would point to the District of Columbia Code, Section 1608.53. And specifically, that is talking about where you are identified with the creation of the senior executive service. This particular statute came into being sometime around March of 1979. We have in November of 1979, the creation of DCRB, identifying it as a separate and independent agency and imbuing and providing to it the ability and the authority to make decisions about
I'm not
classifications.
following why you're taking me to the legislative history. I'm reading the statute as it exists, and it says that someone who's the general counsel of an independent agency is part of the senior executive service. And then we know from other parts of the statute that someone who's part of the senior executive service is an at-will employee, does not need to be, there doesn't need to be any showing of cause to terminate them. So it seems, I guess I'm wondering, what would we remand for if there's no dispute that your client is a general counsel and there's no dispute that she works for an independent agency?
So there is a dispute, and that dispute was identified with our briefs, the brief that we presented here.
Well, there's a dispute about whether or not she's career service, but there's no dispute that she's a general counsel, correct?
We are not disputing that she held the title as general counsel.
There's
What we're
no
off-
dispute that she worked for the retirement board.
No dispute that she worked for the retirement board.
There's
The
no
issue
dispute that the retirement board is an independent agency.
that is an independent agency, and what you heard from counsel in arguing is that they had the ability, our argument that there was an ability to classify her did not relate to her classification as an attorney, and that is what we dispute.
Well,
Specifically,
But I think their argument is actually that classification as a statutory matter refers just to compensation, right? Are you a level 1 or a level 2 or a, however they have the hierarchy, what's your payment band? Because if you read the statutes, it seems pretty clear that all those provisions about classification is about ensuring that, that compensation isn't arbitrary, that sort of like positions are compensated similarly. And so it doesn't seem to have anything to do with hiring and firing. It's about payment of money.
Your Honor, if you will permit, in terms of answering your question, I think when counsel was speaking to this court, he pointed out that there was allegedly some shared misunderstanding about Ms. Sampson's status. There is no misunderstanding. The status given to Ms. Sampson was provided to her when she was with DCRB. It's indicated in her SF-50. When she was removed from DCRB, it was identified in her removal letter of the steps and the actions that she was able to take. And when this case was originally presented to the OEA, the Office of Employee Appeals, the appellee did not make any attack or any distinction because it had the ability under the Enabling Act. Congress enabled DCRB and allowed it as an independent agency to identify how its employees are classified. After Ms. Sampson was terminated.
Can I ask you, though, Judge Easterly asked you a question about how they're classified, and her question was, as a matter of law, your opponent's argument that classified doesn't allow you to move people from service to service or to affect the provisions that relate to what service you are in, and instead is a narrower authority given to the board to, within the confines of subchapter 6 of Title I, to determine compensation amounts and related things. And so I'm not quite sure yet I've heard a response to that legal question about why you think classification provided authority to treat your client as a career service employee.
What I'm saying, Your Honors, is that when you're looking at this particular statute that you are being referred to, which was established in March of 1979, that identifies the creation of a senior executive attorney, what it is not taking into consideration is post this particular statute, you had Congress providing through an enabling statute the rights and entitlements that DCRB had. And our argument, our position is that this was something that was provided and given to the DCRB after and with this existence.
Again, to return to Judge McLeese's and my question, what authority do you have to say that classification means something more than compensation bands, and that it actually encompasses whether or not the person is career service or SEAS?
So what I have, Your Honors, is the request that in addition to looking at this particular statute, which we're not saying doesn't say that if you are in this, the creation of this, but there were steps that had to be taken to get you into this program. You had to be appointed. You had to receive a letter in writing appointing you as such. And I'm pointing to, what is this, section, DCRB's enabling statute, which came into being in November of 1979.
I'm familiar, I'm still not understanding what authority you were pointing to say classification means something more than how you were paid.
What I'm pointing to is the fact.
You're returning to facts, but I'm asking for a law.
So all I can provide at this juncture in response to what you've asked is the fact that the enabling statute that came into being in 1979, November, post this particular statute, 160853, was what DCRB acted under in creating and identifying.
Right, and I'm not sure, I guess, to follow that train of thought, I'm not sure why the fact that the DCRB was created subsequent to the enactment of DC Code 1608.53 helps you, because it seems like the existence of the Senior Executive Attorney Service in the DC Code was then the foundation, it was pre-existing, and the creation of the DC Retirement Board was layered onto that. They understood that there was this thing called the Senior Executive Attorney Service, and they were just talking in DC Code 1-711K, which I believe you're referring to,
Yes.
about classification, about how people are paid, because as counsel for the board has already pointed out, in 1-711 G2A, I think I've got the numbers right, the statute says that the board can appoint any staff, but that the staff shall be subject to Chapter 6 of Title I, which includes the definitional provisions that we've already discussed and the Senior Executive Attorney Service provisions we've discussed.
And so with respect to what Your Honor has pointed out in terms of what this particular statute provides, what I offer with respect to what you've stated and the request for a response is that I do not agree that there was a shared misunderstanding, which is so clearly now being argued to the court as not being one. But it was not a shared misunderstanding. This is something that even post Ms. Sampson's departure, the DCRB board took steps to further clarify that every attorney who is joining DCRB will now be under this provision, because they were not previously under that provision. Ms. Sampson has an SF-50 that's a part of our appendix here that shows her classification. And it's not just for pay or compensation. When she was removed, the DCRB board gave her notification that she could appeal to OEA. And when we were before OEA, and even before this honorable court in a different proceeding, There was never an indication or a challenge that there was this classification misconstrued in terms of what it meant. It was a classification of her. She needed to be in legal services, which she was not.
Can I ask you a question about that?
Yes.
Or about something related that you said a little bit ago, which is you were suggesting that she was not in the senior executive attorney service because no one appointed her to such a position. So you're suggesting there was
Legal
like some.
services. She was
I
not
understood,
in
but focusing for a minute on senior executive attorney service. That seems to contemplate the idea that there are some steps that need to be taken in order for someone as a matter of law to be in that service. And I'm just wondering about why you say that. And in particular, if you go to the definitional provision of what a senior executive attorney service position means, that definition in 1-608-51 3 says, senior executive attorney service position means, and then subsection C is any attorney who is a general counsel. It doesn't say anybody who is, following administrative steps are taken. It seems by operation of law, if you are the general counsel employed by an independent agency, a statute has designated you as having a senior executive attorney service position without a need for some further action by the independent agency. Why do you think there's a need for some further steps for Ms. Sampson to be understood to be having had a senior executive attorney service position?
What I'm saying, Your Honor, is that with respect to her being a part of that, there were steps that were not taken. So she wasn't
But
part of that.
and what I'm asking you is what is your basis for claiming that there are steps that need to be taken other than giving her the position of general counsel in an independent agency?
6B, DCMR 3600.1 indicates that for a senior executive attorney service appointment, you have to specifically reference, it specifically references that the attorney has to be appointed. Ms. Sampson was never appointed to this service at any point. Now, post her removal, steps were taken to classify attorneys in this way. They were made, I submit, as an appointment of this, but this court seems to overlook the fact that the appellant put in play the process that led all of us to the OEA by direction to Ms. Sampson, by argument to the OEA, and also by argument to this honorable court in a different proceeding, identifying her as career service, and even arguing that she had failed to exhaust specific administrative remedies that she would never have if she were in fact under this particular section. And so at this juncture—
I don't think we're unaware of it. The question is we're trying to just assess the legal significance of that relative to the other statutory provisions. And I mean, if for some reason DCRB had been operating under the incorrect impression that Ms. Sampson could be removed only by impeachment of the DC Council and had told her that from the beginning of her employment and then started up an impeachment proceeding and all that, and then halfway through it or however far through it realized that, well, I don't know why we thought that doesn't seem to be what the law is, would you say that your client would have, in this hypothetical, had like a vested right to completion of an impeachment removal process, because that's what people seem to understand, maybe legally incorrectly?
I see my time is up, but I'm happy to answer, Your Honor. No, I would not say that, because I'm saying in this particular case, there wasn't this right or wrong as being argued here in terms of the entitlement and the classification of Ms. Sampson. What I'm saying is that she was identified as an independent agency. DCRB had the ability to classify her as a career service employee, which it did. And that is what I'm saying. It wouldn't be a right or wrong, and so we have to fix a wrong. I think what we're doing is allowing the appellant in this case to make whatever argument seem to be appropriate for any position that they want to take for a win. Because like I said, it's not simply in the OEA or at the OEA level where this was argued. This was also argued in a different court, which came up to this Court of Appeal, which was, my understanding, argued before two of you judges who are present here today, and the position was not that she was this senior executive attorney service employee. This is, in my opinion, and what we believe, a shifting position to deal with any avenue or areas. This is not a case where they were wrongly doing something and now they want to correct it. They had the opportunity at every stage to utilize this statute and place her as a senior executive attorney in the senior executive attorney service, and they did not. And so at this particular juncture, up until the time that she was removed, everything they did with her was because they had the discretion and the ability to do it. And it's very convenient now, with all the different arguments that we've heard throughout this case, which has been going on for years, that it is now this statute that suddenly is crystal clear and something that needs to be followed. There was no inability to actually identify Ms. Sampson at any stage of this litigation as a senior executive attorney in the senior executive attorney service. It did not, and I don't believe that the existence of the statute alone closes the door and squares the question as to whether or not she was in fact under that program. She was not. And there are things that did not occur. There was no appointment, and therefore, at this juncture, what we are looking at is not a clear error by Judge Pittman. It is a valid question that is being presented to the OEA on this issue, which is appropriately addressed before that tribunal, because this is not a final action by Judge Pittman, and this is not a clear error matter where there has been no evidence before this court that it is. There's an argument that we've been addressing and I've been addressing about what the statute said, but it's not clear, simply based on this record. Thank you, Your Honors.
Thank you. Council will give you 3 minutes.
Your Honors, I don't think you heard an answer on the statutory framework that makes this position a part of the senior executive attorney service. There were 2 points that were focused on. First, the idea that an attorney has to be appointed before they become a member of the senior executive attorney service. That's not correct, Judge McLeese. As you read, the statute just talks about an employee who is the general counsel of an independent agency is a member of the senior executive attorney service. And Judge Ishalita, the question you asked first, the Superior Court did quote that statute at JA 106, and so recognize that statutory definition. I would also add on this point, section 1-608.54, which is entitled Appointment of Attorneys. It does not use the word appointment in the provisions. It talks about attorneys being employed by or hired by different agencies. The employment is what triggers the status. There's no separate act of appointing.
Your opponent suggested that there might be a regulation that might impose some kind of an appointment requirement. Do you have a response to that?
You can't contradict the statutes, and I
understand that.
I think they are consistent with what I just explained. Appointment is employment. The other point on the statutes was discussion of whether classification can be which service or within, and I did not hear any basis for arguing that the DCRB has the authority to decide which service an employee belongs to. Again, if you look, subsection K of DCRB's charter statute cites subchapter 11, and if you look at 1-611.01 of that, in that subchapter, it says the classification of all positions in the career, educational, legal, accepted, and management supervisory services will be accomplished in accordance with the following policy. And it talks about identifying by classes and grades where a position will be grouped. And it says the grade levels of all positions in those services shall be based on these considerations. So this is not a question of deciding which service an employee belongs to. It is where within a service they would be placed. So there's no answer on the statutory framework. Instead, my friend argued facts, but I didn't hear any explanation of how those can override an unambiguous provision or provisions of the DC Code. And of course, parties can't, by agreement or otherwise, change what the DC Code says. And I want to respond to one specific point in there, which was about the judicial estoppel argument and the other proceedings. As we explained in our brief, Ms. Sampson's whistleblower claim and other causes of action, we asserted in response to some of those causes of action an exhaustion argument as well as other arguments. The Superior Court dismissed it not only on that exhaustion argument, but also because the other arguments were not even contested and were meritorious, as the court said. And so it failed for reasons wholly independent of this. Counsel said that we said nothing about this on appeal. Well, the only claim that was appealed was the whistleblower claim, which did not implicate this argument. So that the decisions in those cases had nothing to do, they would have been the same as they came out as, regardless of this issue. I'll just end by saying where we are is with a remand to an agency that unambiguously lacks jurisdiction for legally irrelevant fact-finding. That's a clear error of law. Thank you.
Thank Thank you very much. Thanks to both sides for your arguments today and your briefing. The case will be submitted. We are adjourned.
All rise.